Blake Lively is in full-blown panic mode. Court filings reveal a desperate attempt to block Wayfair's motion, and the cracks in her case are finally starting to show. From disputed timelines to questionable legal maneuvers, this battle has spiraled into a high-stakes showdown. And now, with a judge stepping in to take control, everything Blake has fought for could be on the line. Let's break it all down. Imagine a courtroom battle so tense that even the smallest filing could determine the survival of a high-profile case. Blake Lively is now facing that exact moment. Blake Lively is terrified her case could be dismissed, and that fear is written all over what was filed in court last night. This came just after I uploaded another video discussing her motion for treble damages under 47.1. Yesterday, her attorneys filed a request demanding denial of the motion for judgment on pleadings, arguing that it was untimely. And if the court refuses to deny it outright, they asked for an extension of time. From the very first line, the filing pushes for denial, giving the impression of a strong opposition. But in reality, it's not quite that. Instead, what they want is nearly a month of extra time to respond. Her lawyers wrote, "To be clear, Ms. Lively is prepared to respond to each of the defendant's arguments at the appropriate time, whether at summary judgment or at trial." But the Wayfair defendant's choice to sit on these supposedly meritless arguments for nearly 9 months means briefing and adjudicating them now would create duplicative work, waste judicial resources, and burden both Ms. Lively and the court with delays caused by Wayfair. They stress that every single argument Wayfair is now raising has been available from the start of the case. And though their counsel hinted at possibly filing this motion during a conference on July 30th, they strategically waited until the response deadline aligned with the very last day for depositions, forcing Lively's attorneys to juggle preparations and examinations of 4 defendants at once. But here's where it gets more dramatic. By the time the motion is fully briefed, the deadline for summary judgment motions will be just days away, meaning that all fact-based challenges in this pleading motion will likely be swallowed up by the record evidence at the summary judgment stage. And yet, the real twist is what her team argues next. It's not just about timing, it's about whether Wayfair's motion even belongs in this fight at all. Just when you think Blake's legal team couldn't twist the narrative any further, they drop an argument that flips the courtroom spotlight directly onto Wayfair's tactics. What her attorneys are really telling the court is this: Wayfair's motion isn't even grounded in law. It's built on facts hidden inside their pleadings. And here's the catch. A judgment on the pleadings cannot be based on disputed facts, only on legal grounds. In their own document, Wayfair admits they're treating Lively's allegations as facts, but claim her pleadings fail anyway. Blake's side calls that false, arguing the motion is actually timely, because judgment on the pleadings is only allowed after pleadings officially close. And Blake herself acknowledges in the same filing that she submitted multiple complaints, her first on December 31st, her second on February 18th, and her third, the second amended complaint, on July 30th, 2025. The law is clear. Judgment on the pleadings comes only after pleadings are closed, unlike a motion to dismiss or summary judgment. If she filed her second amended complaint on July 30th, then Wayfair had until August 13th to respond, and her reply would have been due around August 20th or 21st. That's barely a delay at all. In fact, it was only 6 weeks after Wayfair's answer that they filed their motion. And you can't file a judgment on pleadings until after filing an answer, so the delay claim collapses under its own weight. But then, in a subtle footnote, something judges rarely rely on for rulings, her attorneys try to paint Wayfair as sloppy. They argue Wayfair's defense included an unexhausted Title VII claim, an affirmative defense they never properly pleaded. That misstep, according to Lively, should not only block Wayfair's motion, but actually entitle her to judgment on that point. Even more striking, they claim she amended her CRD complaint and secured a right-to-sue letter during this litigation, which should cover the exhaustion requirement. But here's the kicker. The California Civil Rights Department doesn't allow a closed complaint to be reopened. Once it's shut, it's over. For her to amend, she would have had to file a brand new action and hand a copy to Wayfair. So if she never provided that so-called amended complaint, and the timing of her right to sue stretches past 300 days, what does that mean for her entire case? If you thought the cracks in Blake Lively's filings were small, brace yourself, because what comes next could blow a hole wide open in her entire legal strategy. Her claim of an amended CRD filing raises eyebrows, because when she first filed, the California Civil Rights Department closed the case the very same day. Once closed, it cannot be reopened. The only option would have been to launch a brand new complaint and serve that on Wayfair, but there's no clear record she ever did. If she somehow tried to update it now, that filing would land more than 300 days after the alleged harassment, well past the legal limit. And if she never gave that updated notice to Wayfair, that's her mistake, not theirs. After all, Wayfair already attached the original CRD complaint she provided in discovery. The big question now, when exactly did she claim this amendment happened? Her team spends pages warning about trial delays, but simultaneously admits the real question here isn't what the pleadings say, it's what the evidence shows. They argue those issues should wait for summary judgment. But here's the contradiction. When the motion raises strictly legal issues, evidence doesn't matter. Legal challenges, like whether her pleadings were even valid, can't be pushed off. And her side insists Wayfair will suffer no prejudice if briefing is delayed. On one hand, they tell the court Wayfair's arguments have no merit and should be ignored. On the other hand, they suggest, even if they're allowed, we'll handle them at summary judgment. It's a contradictory stance that reveals just how shaky their footing might be. Summary judgment allows both sides to pull in everything: depositions, documents, texts, contracts, even video evidence, to argue why the case should end or continue. Both sides are expected to file them, and Lively claims she has new evidence to present. But discovery has already closed, and that's exactly what fuels her frustration. And here's where the stakes explode. Because if discovery really is over, then what happens to Blake's so-called new evidence? Just when Blake thought she could use fresh evidence to keep her claims alive, the courtroom clock strikes back, and this deadline could crush her case. Fact discovery officially closed on September 30th. That means Blake can't simply tack on new evidence now, no matter how badly she wants to. Yes, there are still a few depositions left and expert discovery underway, but the critical window for gathering facts is gone. And that's why her frustration is boiling over, because without new facts, her case risks collapsing. The brutal truth: Wayfair might not even need to answer her claims if the law itself bars them. Her filings obsess over right-to-sue letters, but sidestep whether her FEHA claims are legally viable in the first place. And when it comes to the California Civil Rights Department, a right-to-sue letter only applies in California, not New York, not New Jersey. Yet Blake chose New York, knowing she held a California right to sue. The federal rules are clear. A motion for judgment on the pleadings can be made once pleadings close, but not so early that it delays trial. Here, it doesn't delay anything. In fact, ruling now could save the court from wasting time and taxpayer money on a trial that isn't legally sound. Denying the motion, on the other hand, could drag this case to trial on unstable ground. Her attorneys cry that Wayfair waited too long. They didn't raise their arguments until September 26th, but with trial scheduled for March 9th, 2026, that timeline is incredibly fast for a case this complex. Multiple defendants, numerous depositions, and a flood of filings all crammed into barely a year. Federal trials rarely move this quickly. Blake's delay argument starts to look flimsy under the weight of reality. And just when you think her reasoning couldn't twist any further, her team tries to redefine fact versus law, setting up a clash that could decide everything. The courtroom isn't just a fight over timelines anymore, it's a collision between fact and law, and Blake's entire case is teetering in the middle. Her team claims the motion raises fact-bound challenges to the sufficiency of her allegations, but that's not true. Issues like whether the FHA applies extraterritorially are purely legal questions, not factual ones. Defamation defenses like fair report privilege and litigation privilege, those are matters of law. Even the civil conspiracy claims fall apart if the underlying legal claims vanish. None of this hinges on facts. It hinges on legal interpretation. But Blake's attorneys try to spin it differently. They argue that because discovery has already unearthed voluminous evidence, she shouldn't be forced to defend her pleadings alone. Instead, she wants the chance to amend her complaint yet again, inserting these new details if Wayfair knocks out her existing claims. But here's the problem: aren't legally valid. If the foundation crumbles, you can't build the case back up with documents and depositions. The reality, if her FEHA claims belong anywhere, it's California, not New York. And if she's allowed to amend, discovery would reopen, dragging this case out indefinitely. The court would then have to measure her new evidence against futility standards, asking if her amendments even make sense under the law. Her lawyers insist Wayfair is saying they can't win on law, but only on evidence. But that's a distortion. This motion isn't about evidence, it's about whether her claims are legally sound in the first place. Imagine if Wayfair tried the same tactic, losing on pleadings, then coming back with a pile of evidence to demand a trial anyway. Blake would erupt. And yet, that's exactly what she's asking for herself. And here's where things explode, because beneath all her legal maneuvering, Blake's filings may reveal something even more damaging: fear that her retaliation claims don't exist at all. If you thought Blake's filings were bold, wait until you see the cracks around her retaliation claims, because this is where her case could completely unravel. Retaliation isn't just a buzzword in court, it's a strict legal claim. To succeed, Blake has to show she was actually retaliated against while still an employee. But here's the dagger. By the time of the film premiere and the August 2024 incidents she points to, her contract had ended. Her employment with It Ends With Us was already over. That means she wasn't even an employee when the alleged retaliation occurred. Legally, that torpedoes her ability to make the claim. And as if that wasn't enough, the judge himself just changed the stakes in real time. At first, Wayfair had until tomorrow to respond. But instead of letting this battle play out on paper, the judge ordered a direct confrontation. Both parties must appear in a live video conference on October 3rd at 2 p.m. via Microsoft Teams. For full transparency, he even ensured the press and public will have dial-in access to listen. That move slams the brakes on Blake's attempt to shortcut the process by asking for a flat-out denial. The judge made it crystal clear. This issue is too serious for back-and-forth filings. It will be argued face-to-face, well, screen-to-screen, in open view of the public. And the issues at stake couldn't be heavier. Did Blake actually exhaust her FEHA claims? Does she even have standing to sue? And most dangerously of all, did she properly plead retaliation when her employment had already ended? October 3rd is looming, and with the spotlight on her, Blake's desperate attempt to dodge the motion may finally backfire in front of the entire world. The countdown is on, and Blake Lively's legal gamble is about to collide with a judge who isn't buying delay tactics. The question is, can she survive the hearing, or will her entire case implode? By ordering the October 3rd video hearing, the judge has stripped Blake of her attempt to frame this motion as nothing more than a stall. He's sending a message. This is serious, it will be argued, and it will be decided quickly. Blake wanted the court to deny the motion outright without debate. Instead, she and her attorneys now have to face pointed questions about FEHA exhaustion, standing damages, and retaliation. There's no hiding behind filings, no shortcuts, no hissy fits on the docket. Wayfair, meanwhile, may even treat Blake's opposition as if it were a full response. But her entire plea boils down to one desperate request. Please deny this because it's untimely. Don't look at whether it's meritless. Don't even evaluate the claims. She's essentially begging the judge to ignore the foundation of the case and buy her more time. And if some of her claims do get knocked out, she's already angling for yet another amendment, something the court may no longer tolerate. Because here's the raw truth. If Blake truly had the evidence she insists she does, it would already be in her second amended complaint. The fact that she's scrambling now suggests the opposite. Retaliation requires proof of real retaliation during employment, but by her own timeline, she wasn't employed when these events took place. That undercuts everything. And so, the October 3rd showdown becomes the turning point. Either Blake convinces the judge her claims should survive, or she watches as the legal walls close in. With transparency for the press and public guaranteed, the whole world will hear the arguments live. The stakes couldn't be higher, and the outcome could redefine this entire lawsuit. So now I want to hear from you. Will Blake Lively's desperate attempt to block Wayfair's motion succeed, or is this the beginning of the end for her case? Drop your thoughts in the comments below. Don't forget to hit that thumbs up, subscribe if you haven't already, and click the bell so you never miss the next update. The drama is only just beginning.